So I'm going to hand over to Keaton and Amelia.
How's it going, everybody?
I could, but yeah.
I'll introduce us. My name is Keaton Turnipseed. I am a business attorney with BPE Law Group. This is Melanie DeMarco. She is also a business attorney. Both of our practices are very heavy into real estate. So the presentation that we have today for you guys is basically some of the common pitfalls that we see either on the litigation side, or just setting up a deal to frankly keep you all out of trouble, right? We spend more time and more of your money fixing problems than we do sort of preventing them in the first place. So again, our presentation is sort of heavy into what we see people generally get themselves into trouble. With that said, we are sort of constrained in terms of time. So I will probably, both Melanie and I will stick around afterwards. If you guys have questions, feel free to come up and chat with us. We're happy to chat. But with that, we'll probably hold questions till the end or after our presentation. So with that.
All right. So kind of generally what we're going to cover today is a deal kind of life cycle. We have structuring the deal kind of right from the first place, how to avoid liability while you do that, and then making sure you have an exit plan. And then we'll talk about some of the mistakes that we've seen going through these. All right. So the first and biggest mistake I see, especially from my side, is we'll figure it out later, or we already get along, like we're great, we've already done this, whatever it is, and not properly papering your deal. That's the biggest thing is the handshake deals or the we want to keep it simple attitude. That's all well and good, but the disputes that we see on the back end are always something that could have been contracted around, and we could have made those decisions beforehand. So we talk about here no entity formation, especially when we're talking about liability. The lawyer in me likes to see some sort of liability shield in there, LLC, whatever. And then no operating agreement, even if you do have that entity in place.
In terms of the entity in place, what we're talking about when we're talking about limiting liability this is the litigation side of things, right? This is something has gone wrong and you end up in court, right? If you have an entity in place, your entity gets sued, not you personally. Meaning all of your personal assets, your personal bank account, your personal car, your own home, right? That is all protected, right? Whereas if you have that entity, the entity is the one that's sued. And at worst, you are losing whatever is in that entity and not your own personal stuff. What certainly I've seen people get in trouble with your entity, you need to keep it separate. Meaning you cannot be paying for groceries with your LLC's credit card, right? What the court will do, the technical legal term is pierce the corporate veil, right? The idea is that there is a separation of veil between you and your entity. But when you yourself start to disregard that distinction, right? Paying for your groceries with the company card, the court too will disregard that and hold you liable for whatever your LLC or corp or whatever it is. An easy example that I litigated a couple years ago, I had a client who had his Porsche, his wife's Mercedes, and his RV all under his company name. Don't do that.
Yeah, I mean, I have a dispute right now where someone had they filed there was a Ferrari.
There was a Ferrari. Don't have the Ferrari in your corporate name. That's not good.
The Ferrari lease.
Still.
No, yeah, they're literally leasing a Ferrari under their real estate holding company. I don't think that's gonna fly. But no, also one where I've seen ones with either no operating agreement and then all they did to form their LLC was file the articles of organization, and they're like, no, we're good. We have an LLC. The court doesn't care that you filed articles of organization for 5 minutes one day 3 years ago. That's not going to cut it either. It's not just commingling. There's lots of formalities, and there's less with an LLC as compared to a corporation. So that makes those formalities that do exist that much more important because you have a little bit less to point to. You're not holding annual meetings like a corporation would. So you have a little bit less to point to as far as the separateness. So it's really important with an LLC, not thinking that because it's more relaxed, you can get away with not doing the things. The other ones are either no operating agreement, or I see a lot of like check the box forms that they found online that do the things, and it's like 3 pages long, and it's they're checking a few check boxes, rightly or wrongly. And then we get to a dispute, and there's no answer as to what happens there. So that's another big problem. The other problem is, we talk about on the last note here is a trust layer. I've had transactions where one of the members of the LLC dies, didn't have an estate plan, and they were in escrow, for I think they were in escrow on like a $4 million building. Couldn't sell it because they had to wait for probate to probate that LLC interest because there was no one there to sign it and no provisions for what to do. And the escrow company says, no, we need both members to sign. And so we had to wait for someone to get appointed. And that transaction didn't close.
And when we're talking about a trust, the way it's structured, if you want to picture it in your mind, right, is you have your trust up here, and that holds all of your assets. This is where you're holding your house, your car, your bank accounts, right? But it's also going to hold your LLC with your rental property and your LLC with your flips, right? So that's that's the top layer of ownership, if you will. Now, to be clear, a lot of people come to me on the litigation side and say, hey, I've got a trust, am I protected from liability? No. Just because you have a trust does not mean that you are protected from liability. A trust is a pass-through entity, meaning if I sue you as a trustee or whatever, I'm still suing you, right? It's only the LLC or the corp or whatever entity you have that is going to give you that corporate shield, right? So if you set this up in the best way possible, right, we have the trust up here, that's going to own all of your stuff, including your different LLCs or corporations or whatever it is that you specifically have moving on.
Can you repeat that again? You said
Sure.
just because you have a trust, it doesn't protect.
It doesn't protect you from liability, right? I told you that when your LLC, when your tenant falls down the stairs, they sue your LLC, yes? That is not the case if your rental property is in the trust. If your rental property is in the trust, they're suing you. So we want that LLC or corp or whatever it is in place. But to avoid the situation that Melanie talked about, right, we want to make sure that LLC is actually in the trust. So when you pass, eventually, right, nobody gets out of this game alive, right? When you pass, we can deal with all of those things that you have going on investment wise.
And actually, Keaton brought up another really good point is multiple LLCs. I've definitely had clients where they had 18 properties in one LLC. And that's great that it's not with your other stuff, I guess. But the reality is all the things that are grouped together are all grouped together. So that liability shield is the LLC itself is, think of it like a bubble. So for every LLC you have, it's its own bubble, and everything in it is going to be subject to attachment if you're ever sued. So that's another thing.
I'm glad we used my laptop.
Me too.
Come on, man.
Is there a number of properties you can hold in one LLC?
So that's up to you, and that's all determined by your risk, right? If you have the situation that I was sort of talking about, right, one LLC per property, right, that's the most protection, because if you get sued, it's that LLC, the most you're losing is that property, right? Now, sort of the flip side is Melanie's 18 properties in one LLC. Obviously, that's a lot more risky. If you get sued, right, and we're talking worst case scenario, right? You get sued, you get that judgment, you're risking those 18 properties. So I don't know. I've always operated about 1.5 million per LLC. So maybe, here in Sac, sometimes that's one property, maybe that's two. I mean, again, it's up to your risk because again, if you have 18 rental properties, do you really want to be dealing with 18 LLCs? Probably not, right? On a practical level. So again, it's up to your risk. I don't know. Do you have a different opinion? I always say 1.5.
Yeah.
Yeah.
So I always,
Right.
yeah, I always say, well, it's really the value of the risk, right? And my recommendation is always to talk to your insurance carrier make sure you don't have $20 million worth of assets in a company with a $2 million policy, right? Because now the overages are going to extend to whatever's there, and so that's really what I look at when I'm advising. If you have a $2 million policy, you're probably safe with about $2 million worth of assets there, because your insurance is going to you know cover any liability that could possibly reach those assets. When you start to have a bunch more property and you still have a $2 million liability policy for that entity, then it starts looking a little scarier. And so it's where are you comfortable with that risk? And then you have to weigh the cost of insuring it and if there's any overages. All right. We talked about this a little bit, but agreements between partners, I see this one come up a lot, and they'll come to me to write an agreement after it's too late, often. And then we're fighting the hard fight about how to distribute things. Contributions and profits and losses, obviously the big one. I have a case right now where they have this lovely property. It's out in Truckee, couple $1 million. They've already done all the work. But it turns out, despite what their operating agreement said, one partner put in more money than the other. And now they're fighting over it because it says, 50-50 distributions. And it's like, well, it also says 50-50 contributions. So how do we equalize that? And we got in a whole fight over it because we're looking at, a swing of $400,000. So that's a really big one, is to note for what happens in those situations, even though your operating agreement may say, 50-50 contributions and 50-50 distributions, having those fail safes in there for what happens when someone doesn't. And a lot of, professional operating agreements will have some sort of option to consider that difference alone and have some sort of payback provisions. And so thinking about the wrong things or someone doing the wrong thing is hard for people when people are getting along. But that's really what I would encourage you to do. They're like, we're best friends, or we've already done 3 flips and everything was great. We're fine. But everyone's friends until they aren't. And that was the situation here where that particular duo had done several big builds before. And here it came out on their, 5th one, something didn't go to plan. And so I know it feels aggressive to people to have those agreements, but really it's less aggressive than the fight will be. So, don't look at it as, I don't want to be the problem when you're setting everything up, but really what you don't want is the problem when everything breaks down.
I think similar with exit provisions. I have a case right now where, 2 partners are dissolving the entity that they have, but they also have 8 different properties or 9 different properties within that entity, and there's no provision that says what do we do with these things. Even if it's fire sale, right? That's still oftentimes a better option than me and opposing counsel going back and forth to figure out who gets what. Why do you get this property? Why do you get that property? Well, give me some money over here, right? So to have that exit provision, I think from my end is obviously super important as well.
All right, so we did talk about this already, but the trust layer, super, super important. So we'll briefly touch on it this way, but yeah, I've definitely had a situation where I was in a transaction, one of the members passed and we were stuck for, a year. We lost our buyer. And it does happen, and it's just one of those situations where you can't see the future. So, do it. It's a lot cheaper to do that than to have a deal stalled. And honestly, it's a lot cheaper than probate anyways, because now your heirs are going to have to pay probate fees on, what would have been otherwise a windfall.
Disclosure. So this is probably the thing that I litigate the most, are our disclosure issues. So what I'm talking about here is when we're selling a house, right? Whether it's a property that was a rental and we're selling it now, whether it's a flip, whatever, right? You need to make your disclosures as accurate as possible, right? And you're like, thanks, Keaton. I'm glad you went to 3 years of law school to tell me that. Like, duh. It's actually increasingly complicated in California. If you're doing flips, there are specific extra on top of the TDS and SPQ, there are extra forms that you need to go through as a flipper and fill out. What that's going to include is all of the names of all of the contractors, they better be licensed, that you used and what all the work was that you did. Now, think about this, right? You buy a junker property, right? And you put hundreds of thousands of dollars in there. You need to be very detailed in terms of what you did to rehab that property. Another thing that I see oftentimes is, well, certainly past repairs. So again, this is even outside the flipper context. I actually see it more litigated with like older people who owned a property for 20, 30, 40 years and have made all different kinds of repairs. So when you make a repair, right? I'm litigating a case right now where there was a roof leak. My clients fixed it and they thought they were good. What you want to say is there was a roof leak. I fixed it. I have not had any problems since, right? Because at that point, the buyer can go do that their own due diligence, right? And do whatever inspections they want to do to figure out if you really did what you were supposed to do in fixing that, right? But to the best of your knowledge, it's fine. The other one that we see a lot is as is, and it's silly. CAR actually has as is language in the RPA, the residential purchase agreement. It's not as is. It's not. It's not. And it's never going to be, right? Not only do you have statutory duties, so 1102, right, disclosure of known material defects, you also have a common law duty, right? So even if you're not subject for whatever reason to 1102, and some people aren't, if you're selling it out of a probate, for example, you're not subject to 1102, you still have a common law duty to disclose. So again, if you know about it, you need to disclose it, even if it's going to tank your property value. It is cheaper to disclose it and sell it for less, sell the property for less, than to come to talk to me and litigate for however long, right?
So if I'm a property owner, if I knew that, for instance, if the trees were growing into the pipes, I had to say that.
Absolutely.
Okay, just
Yeah,
make sure I'm on the same page.
anything that is going to affect the value or desirability of the property. Easy way to think about it is if you would want to know whatever that fact is about a property you were buying, you should probably disclose it. And again, lean on over disclosure, right? I have clients and agents, they tell me, Keen, I don't want to over disclose because it's going to tank my property price, right? And yeah, it might, but again, it'll be cheaper to get a lower sales price than to come litigate with me. I know I'm lovely, but
My understanding is you really only have to disclose as a owner or a seller if it's for residential. Right? So
yes, it's very different for commercial.
then like buyer beware, you have to do your own inspection.
So
Yes, go ahead.
I was gonna say there is still the common law duty. So
Yeah.
if you know of something, you still have to disclose it. You are just exempt from like the TDS and the SPQ. You're not subject to the like form statutory disclosures, but definitely we've litigated a commercial failure to disclose. If you know that I have one right now, you know that basement floods, you have to disclose it regardless of commercial or not.
Actually, I've seen people because different, brokerages. I can't remember the brokerage that I litigated. It was in like December. The client I stole from you. They have that brokerage has basically a disclosure form, and they just put it into their packet with all of their other documents that, in that case, my client filled out. So he went down this disclosure packet and did no, even though he knew about some problems, right? So aside from your common law duty to disclose, if you have something like that, even if you're not obligated to fill it out, you do, we start talking about fraud or at the very least negligent misrepresentation, right? Yeah, did you have a question, sir?
I'm saying, what if there's evidence of this major repair, but you didn't do it? It just was there in the past. You gonna say something, or you just
Sure. So again, speaking residential, right? A buyer has a duty to do what we call a reasonable inspection. The example that I always give clients in consults is if a seller comes to you and said, the basement does not flood. It's never flooded. It's great. It's magical. You go walk through 6 inches of water in that basement. Even though that seller sat there and lied to your face, you as the buyer are on the hook because you knew about it. So again, I think that the belt and suspenders way to do it is, hey, there is a stain on this wall. I don't know what it is, right? But again, you have that fallback defense that there's a stain on the wall. It's pretty obvious, right? Agents, you get into the Avid, the agent's visual inspection. Sometimes they'll mention stuff. Generally, Avids are pretty useless. Litigating, for good reason. Agents are trying to protect themselves, and frankly, I advise them too. But I think that gets to your question.
All right. Moving on. All right. So we're going to talk about financing. The regular kind of loan way is a little bit more obvious. Private financing will raise a few more questions for people. So there's a couple ways for financing. We have debt financing, equity partnerships, and hybrid structures. So your regular debt financing is sort of your typical type of mortgage, as you would think of it. You have your regular security interests. In California, that's a deed of trust versus a mortgage. And then those are usually just regular secured loans. Equity partnerships, where is when you're going to exchange equity in your company for some sort of repayment obligation. So you'll see this in a situation. I see it a lot with like contractors who are like, well, I'm going to do the labor, you're going to provide some of the money, and then I'll pay you back for it out of the profits. So that's pretty common on, we'll structure that sometimes as like a joint venture or some sort of preferred profit return if we do that. A hybrid structure is simply a combination of the two. Maybe you have a purchase money mortgage that's going to handle part of it, but then you have someone else who's going to finance some of the construction or rehab or whatever you're going to do. All right. Most important are your financing docs. You guys know what I'm talking about. You have your promissory note, deed of trust, and sometimes, depending on the loan structure, you'll also have a loan agreement. The promissory note is your actual contract, and then the deed of trust is just the security agreement. Other states call it a mortgage. We call it a deed of trust here, but it's a mortgage. So that's the document that links your promissory note to the property, so that if you need to get it back, you have the property to look to. A loan agreement you typically see in more complex loans. A lot of times with private financing, you don't always need both. Like I said, you'll see that mostly in private, more complex financing with different payment terms. But a lot of times you don't. Okay. Switching, I guess this is just funding. We have the 1031 exchange. I'm going to talk about this very briefly. The idea of a 1031 exchange is just to defer your capital gains tax liability by reinvesting in a like-kind investment. So this can, put your capital gains off because you're putting that money that you earned by selling one property into another. It's important to know that if you're selling real estate, it has to be reinvested in real estate. If you're selling an LLC interest, then it has to be reinvested in LLC interest. So depending on the structure of your sale and what those capital gains are characterized as, it has to be a like kind of exchange. Most of the time you see that as real estate for real estate, but it can be other things. No, it doesn't have to stay in the same LLC. But if you're selling, instead of selling the real estate out of the LLC, if you're selling the LLC interest, and you're selling an LLC, that money has to go, your capital is the membership interest versus the real estate. Then in that case, it has to be like kind of invested into the same type.
So if I'm an investor and we leave the deal, we that set, and they 1031 their interest from my syndication into a different syndication.
Yes. Yeah. So as long as it's a like kind exchange, you can have partial interest, whatever. It has to be. There's lots of rules about that. You have to have the same equity ratio. So if you're selling 20% of a property over here, you have to end up with at least that much in, if not in ownership, even if your portion doesn't cover it. So I had one recently where he sold, his interest was worth $1 million and he owned 50%, but he's putting it into a $4 million property. So he has to come up with the other, $1 million worth of.
Oh, so if he comes up with the additional million, then his million that he transfers over is still.
Can still be deferred. Yeah. So as long as you end up with the same ratio. We'll talk about that offline, or maybe you can talk about that with him.
Syndication.
We'll talk about that offline. Yeah, you're good.
Yeah. All right. I guess the other important thing, really strict time rules. There's no delays there, no extensions, no savings clauses. Have to hit your timelines. No other reason. I'm litigating that one right now too.
If you don't, you're host.
Yeah. All right. Protecting your deal, always really important. So if you end up being the lender, make sure you get your security properly secure. That sounds stupid, but actually that's what I mean. Make sure it's properly secure to the property. Define what a default is and when you can act on it, and then make sure you have that exit strategy as we've talked about.
Yeah. Okay. So exiting your deal, right? The things that are going to hold up a deal, and actually this top issue I'm dealing with right now, client got into escrow and realized she didn't actually have clear title. So make sure you have clear title. When I say clear title, what I mean is you, or at least the people who are everybody who is selling the property owns it. We don't have, in the case that I'm litigating, great Aunt Mary from 1840, whose interest went God knows where, right? Sort of hanging out there. We want to make sure that the people selling the property have the right to sell the property in its entirety. Same thing with liens. We see this a lot with mechanics liens. Tax liens are also a big one. Make sure all of that is cleared before we get too far into a transaction. That is what is going to potentially, blow up the deal entirely, but certainly will slow it down. And then disputes, right? Again, this goes back to the disclosures. If you are litigating with your neighbor over where the boundary line is, one, you need to disclose that, but two, you're probably not going to be able to close because again, you run into these title issues, right? A buyer is not going to want to buy a pending litigation. I actually met with a client a couple days ago because her neighbor is stymieing the deal. The neighbor doesn't like loud noises, in particular children, which seems like a low bar to me, but whatever, what do I know? That dispute is causing delays and causing her not to get buyers, right? So again, make sure everything is buttoned up appropriately with your title, your liens, and then whatever disputes are going on with regard to neighbors or whatever else. So yeah, are we, huh?
Sure enough.
Okay.
The last one is key takeaways. So
Okay, yeah.
last one's separate. We're good.
Yeah, so we'll stick around for a little bit. Thank you guys for having us. And yeah, we'll stick around. Happy to answer any questions you guys may have.